This is a short bulletin from Mills Reeve on building safety matters. Now, if you're after a detailed discussion of those issues, you'll find a series of blog posts and webinars on our building safety webpage. But today, we just wanted to raise some practical points that you might need to be thinking about right now. Some of those arise from statutory provisions coming into effect on the 1st of October, and others relate to clarifications provided in recent court and tribunal decisions, which might be relevant to your assessment of potential or ongoing claims. To talk you through the headlines, I am joined by three experts in the team, Iain Murdoch, Ed Freeman and Alison Garrett, and a first dispatch from Iain.
Thanks, Dom. I'm here today to talk to you about principal designers and principal contractors, but I'm not talking to you about those roles under the CDM regulations where you might be familiar, rather the fact that these roles now apply under the building regulations too. And this applies to all buildings, not just higher risk buildings, and it applies from the 1st of October this year. There are some transitional provisions that apply if you've already started work and your building regulations plans are already lodged, but the duty holder roles have been introduced to the building regulations, and they mirror the names of the roles and many of the themes for those roles under the CDM regulations. For example, there's similar obligations for all of the duty holders to cooperate and collaborate with one another. So in summary, and the rules can be different, for example, if there's only one contractor, the duty holders are client, contractor, designer, principal designer and principal contractor, and competence checks apply to all of those roles. They are similar but not identical to the competence checks required by the CDM regulations. And critically, from the client developer side, the client must appoint a principal designer and a principal contractor, and that appointment must be in relation to the building regulations, not only in relation to the CDM regulations. We anticipate that in most instances, the person with that duty holder role under the CDM will also have that role under the building regulations, but there's no requirement for exactly the same person to hold that role. And one of the key things to be aware of now is at the end of the building regulations process, when you're completed your project, the client, principal designer and principal contractor must confirm that they've taken all reasonable steps to ensure that the building work complies with the building regulations. And that language, we're told by the government consultation that preceded the regulations, is intended to satisfy at least some of the concerns of the professional indemnity insurance market. So be aware that from the 1st of October this year, and if you're in one of the transitional regimes from the 6th of April next year, you're going to have to make these appointments where you're performing building work. And with that, it's over to Ed.
Thank you, Iain. Following on from the theme of things arising out of the terrible events of Grenfell, but with implications well beyond fire safety, comes the Court of Appeal decision in URS and BDW. Post-Grenfell, the developer BDW had investigated developments it had previously carried out and found serious structural issues with some that had been designed by URS. It spent money investigating and dealing with the fallout of these issues and sued URS. URS appealed some points that had been decided by first instance judges as preliminary issues and in relation to requests by BDW to amend its claim, leading to potential clarification of some important issues. First, as you may be aware, the Building Safety Act has extended the time periods for bringing claims under the Defective Premises Act. The Defective Premises Act allows for the bringing of claims where dwellings are not habitable. Even though proceedings had commenced before the Building Safety Act came into effect in relation to these provisions, the claim could be amended to benefit from these extended time periods, provided that the claim had not already been settled between the parties or in court. Second, it was previously unclear whether developers potentially facing a claim under the Defective Premises Act could bring a claim against a party responsible, such as a designer. It now appears that a developer can bring such a claim. Third, another method for a developer recovering from its supply chain in respect of claims it might potentially face from third parties is to use the Civil Liability Contribution Act. It was clarified that the developer did not necessarily have to have received the third-party claim to start proceedings under the Civil Liability Contribution Act against the designer, provided the requirements under the Civil Liability Contribution Act had otherwise been fulfilled. It will be interesting to see whether there are any further nuggets arising from this case in the future, but it raises issues potentially up and down the supply chain and should certainly be taken into account for ongoing claims. And with that, over to Alison.
Thanks, Ed. I'm going to talk about remediation orders, which were introduced by the Building Safety Act last year in 2022. Recently, in the last month or so, we have seen the first remediation order being made, and we've got a feel for how the first tier tribunal, which is the tribunal that makes such orders, will deal with these. Remediation orders apply if you have a self-contained building over 11 metres or 5 stories in height with 2 or more dwellings. In this particular case, the first tier tribunal made some key decisions and decided that, in fact, the KEDI Limited, who were the freehold owners of the property, should undertake remedial work. They made 3 key points which are worth noting. Firstly, that the Building Safety Act is not prescriptive as to the work to be done, and that the remedial works that are required must comply with building regulations at the time the remedial work is done, which is perhaps not surprising, but it's good to have it clarified. Second, the period of time for rectification was debated. KEDI wanted longer than the leaseholders who said that the work could be done much quicker. The tribunal took the view that they would give KEDI the time it had asked for. The underlying theme appears to be that the tribunal is more concerned that the work is done properly than that it is done quickly. And thirdly, the cost of proceedings. There were 2 aspects to costs in relation to this matter. The cost of the actual remedial works, which KEDI had to fund itself because it had been responsible or involved in the original works. But secondly, also the cost of the remediation order proceedings. Now, there could be no order made by the tribunal that the leaseholders be responsible for any of KEDI's costs, even if the tribunal had wanted to award that, because unless one party has been unreasonable, the tribunal will not make an order between the parties. What the tribunal did say is that although KEDI could not bring a claim or could not have a claim for the cost of taking proceedings against qualifying leaseholders, it was entitled to seek a contribution to its costs against non-qualifying leaseholders through the service charge. It limited that to 20% of the costs incurred by KEDI. Back to Dom.
Thanks, Alison, and thanks all of you for some really pithy and pertinent updates, giving a good deal of food for thought. Before we sign off, there are a few key developments to highlight for those of you with higher risk buildings in your portfolios. And as a reminder, a building is higher risk if it is over 18 metres or 7 stories high and has 2 or more residential units. So first, a reminder that the deadline for registering occupied higher risk buildings with the regulator is fast approaching at the end of this month, 30th of September. And second, the building safety regulator becomes the building control authority for high risk buildings from the 1st of October, meaning the Gateway 2 requirement for approval prior to commencing works kicks in. And be mindful of the timeframes that the regulator has to determine applications for approval, which are 12 weeks for new build and 8 weeks for existing buildings. And also the requirement for a completion certificate before the building can be occupied, which is known as Gateway 3. Importantly, that application will need to be made after practical completion of the works has been achieved, and the regulator then has 8 weeks to deliberate on that, so a further delay to take into account. And that brings things to a close, although there's plenty more information on high-risk buildings and indeed building safety matters generally on our building safety website. If there's anything today that we've discussed that resonates, please get in touch, and our contact details will be circulated with this bulletin. So thank you to my co-contributors, and thank you to you all for listening to our bulletin.